Hi, welcome back. We're here for Module 8, which is Week 9 on problems of proof. And in this section, we're going to talk about the law navigating a fog of uncertainty. In attempting to figure out what happened in the past, the legal system must deal with faulty recollections, lost documents, missing witnesses, inattentive jurors, and countless other impediments to knowing with very much confidence what actually took place months or years before the trial happens. Not only does the law do its work under conditions of uncertainty, but the legal system is also a complex one in which the separation of powers is a dominant consideration. Under the conditions of uncertainty and divided responsibilities, the burden of proof and its companion concepts of deference and presumption play a huge role. These concepts shed light on how sure the legal system needs to be in order to reach a particular conclusion. So that's what we're going to look at through a number of articles in this section. The first article assigned is Proving the Law by Gary Lawson. This article seeks to explore and challenge conventions surrounding legal proof and determination of what constitutes the law. It delves into the intricacies of how legal practitioners and scholars perceive and engage with legal texts, questioning the standard approaches of interpreting legal documents and statutes. Lawson's work revolves around concepts of legal proof, scrutinizing how legal actors ascertain and establish what the law is in a given context. And he contends that there is a prevalent disconnect between the methodologies employed and used in legal interpretation and those used in other disciplines. In legal settings, there seems to be an implicit acceptance of standards and practices that would be deemed inadequate or insufficient in other fields of inquiry. And Lawson urges a reassessment of how legal professionals approach the task of proving the law, advocating for more rigorous and methodical sound practice. He delves into philosophical underpinnings of legal proof, and he grapples with questions about the nature of legal texts and challenges some of the foundational assumptions that underlie common legal practice. Ultimately, proving the law serves as a call to action, encouraging legal scholars and practitioners to adopt more critical and reflective stance towards their work. He pushes for a more rigorous and principled approach to determining what the law is and how it should be applied. Some of these concepts can be found and thoughts that he has on page 895, where he talks about legal propositions that they face much lower standards and hurdles than factual propositions, because he spends a great deal of time looking at standards of proof beyond a reasonable doubt and clear and convincing and preponderance of the evidence, but that we don't apply those same standards to the legal. We don't apply those legal standards to legal standards in the law. That proving the law seems like an odd phrase indeed, and that it's impossible to be certain why the law freely speaks of proof when there's a factual proposition, but not when legal propositions are at issue. And again, those conclusions are found on page 895 of the reading. There's a couple of examples in your lecture notes of how his interpretation has real-life implications. There's an example in patent law and environmental law and contract law that you'll want to look at as to that article as well. The second article this week is by John Kaplan, and it is looking at decision theory and the fact-finding process. This article looks at statistical decision theory and tries to apply that and the fundamental concepts of probability, expectation, and utility in the legal context. Kaplan, in his work, delves into the intersection of decision theory and legal proceedings, emphasizing how understanding and applying decision theory can enhance the fact-finding process in legal contexts. Decision theory is a branch of mathematics and philosophy that deals with how choices are made in uncertain circumstances. And as you're looking at his article, he's going to attempt to give you problems, mathematical problems and calculations in determining probability expectations in the legal context. Kaplan then talks about in courts, decisions are based on the available evidence and the perceived reliability of that evidence. However, his contention is these decisions are often made under conditions of uncertainty, since absolute certainty is rarely achievable in legal matters. He suggests applying the decision theory to legal proceedings requires a shift in how we perceive and handle uncertainty, and that traditionally the legal system has aimed to minimize the chances of incorrect decisions. But he points out that this approach doesn't necessarily optimize justice and fairness. He advocates for the use of decision theory to systematically analyze and weigh potential outcomes of different decisions. And he believes that legal practitioners can make more informed and just decisions, even in the face of uncertainty, by using these decision theories. His exploration of how decision theory can be applied to various stages of legal process, from evidence gathering to the final judgment, and he provides a fit framework for integrating decision theory into legal practice, highlighting the importance of clear criteria and consistent methodology. He argues that this can lead to more transparent and accountable decision making. And he seeks to demonstrate how a systematic decision theoretical approach can lead to more just and reliable outcomes. Again, in your notes, there are real life examples trying to apply these theories in cases, criminal cases, personal injury cases, and patent law. So you'll want to look at those to put Kaplan's theories, decision theories, and the fact-finding process into context. The third article this week is by Ronald Allen, and it is the nature of judicial proof probability as a tool in plausible reasoning. He delves into the intricacy of proof and how probability plays a role. And he states that proof is not solely about finding the objective truth, but rather about making rational decisions given the available evidence, which is what you always have at a trial. You have the available witnesses and evidence in written or pictorial form. He then asserts that the legal system operates on the basis of plausibility rather than certainty. And he critically examines the role of probability in the process of proof. He acknowledges that while probability is a valuable tool in assessing evidence and making legal determinations, it shouldn't be the sole determinant. He argues that proof requires a broader perspective that considers context, narrative coherence, and plausibility of evidence. Ronald Allen calls for a holistic approach to proof and underscores the importance of the context, narrative coherence, and a thorough understanding of the evidence in play. He talks on page 7 about litigation being dynamic and legal proof being comparative in nature. And then on page 9 states that without formalisms, what is left is judgment rendered by disinterested people striving to do their job honorably, assisted by motivated parties who have the correct incentives to investigate and present evidence, and that this is in fact a methodology. Here again, the notes are going to give you examples about, for instance, eyewitness testimony. Talks about in a criminal case, an eyewitness claims to have seen the defendant commit a crime. The witness seems confident, but there are discrepancies in their account when compared to other evidence. Allen's work would encourage the court to not rely solely on probability associated with the witness's probability, i.e., witnesses are right 75% of the time. Instead, the court should consider the plausibility of the witness's story in the context of all available evidence, recognizing that human memory is fallible and influenced by various factors. The goal is to achieve a holistic understanding of the evidence to make a rational decision rather than relying just on the probability of that eyewitness account. The fourth and final law review article for this week is Michael Pardo's Judicial Proof and the Best Explanation. I want to look first at his introduction, where he talks about, from the fact that some propositions would explain a given phenomenon, we infer from that the proposition is in fact true, and that the proof process involves similar inferential practices. Again, looking at the introduction of the article, he talks about that to demonstrate that the process of inference to the best explanation itself best explains both macro structure of the proof at trial and the micro level issues regarding relevance and the value of a particular item of evidence is what he is seeking to demonstrate in this essay, and to show that probability-based accounts rather than being an alternative or parasitic on a more fundamental explanation-based consideration. So he presents a philosophical and analytical perspective on how courts should approach the process of evaluating evidence and arriving at judicial decisions. He emphasizes the importance of understanding evidence in terms of its explanatory value to ensure that the legal system reaches accurate and just conclusions. Pardoe critiques the prevalent probabilistic model of evidence and legal proof. He suggests that these models sometimes lead to counterintuitive and unjust results. He argues that probability alone should not be the sole criteria for evaluating evidence, as it often ignores the complexity and nuances of real-life situations, so that he proposes a shift to a more explanatory model, where the focus is on how well the available evidence explains the events or facts in question. He delves into the concept of inference to the best explanation, which he shortens as IBE, proposing its more suitable and effective method for judicial proof. IBE is a form of reasoning that involves selecting the hypothesis or explanation that best accounts for the available evidence. In legal context, this would mean that judges and juries should base their decisions on which narrative or account of events is best supported by the evidence that is presented within that trial. Pardoe also emphasizes that it's not a subjective or an arbitrary method, but rather a structural and rational approach to evidence evaluation. He highlights the importance of transparency, coherence, and rigor in applying the inference to the best explanation, which ensures that the chosen explanation genuinely aligns with the available evidence and is not the product of bias or preconceived notions. Pardoe then connects his theory to broader themes, demonstrating the relevance and applicability beyond the legal realm, and he underscores the importance, again, of inference to the best explanation, IBE, to enhance the accuracy and fairness of judicial proof, contributing to more reliable, just legal system, in his opinion. Again, there are examples provided to you in the information. The first one being a wrongful conviction of a man who is convicted of a crime based on eyewitness testimony and circumstantial evidence. The probability model suggests he is the likely culprit due to his presence at the scene and the vague identification of a witness. But the application to Pardoe's work is that Pardoe's explanatory model, the court would re-examine the evidence to see which explanation best fits the facts. The man's lawyer presents an alternative theory showing that the timeline doesn't add up and the eyewitness was not wearing their glasses. The best explanation may shift away from the man's guilt towards a possible misidentification. So the outcome is that the man's conviction is reevaluated and he's found not guilty, demonstrating how the explanatory model can prevent wrongful convictions and contribute to a more accurate and just legal system. Tied in with those, we're looking this week in the book in Why the Law is So Perverse. We are looking at the last chapter, chapter 9, in the loophole sections. This is on intentional fouls. If you recall, intentional fouls are violations in rules in which the violator fully expects to incur the penalty, but rightly calculates that he'll come out ahead, that by doing an intentional foul, that he will have a better outcome, which then is a kind of loophole because the person who does this intentional foul comes out with a net advantage despite breaking the rules. So he gives some examples of this. His first example is crimes of mitigation. This is found on page 127 of the book. The discussion of this begins, and this is about a defendant who poisons 5 people, and they have a glitchin. This is a made-up organ that is going to fail based on this poisoning. So he has the ability, the defendant, to grab an innocent bystander and extract the bulk of that person's glitchin and parcel it out among his victims. And so the argument is, should he do that? And if he does what we think he should do, which is not assault the innocent bystander, if he does that, 5 people die, and he will be guilty of 5 murders. Conversely, if he instead decides that he's going to disregard the fact that he should not now assault this innocent bystander, and he does in fact assault them, removes part of their glichen, and then slices it up, transplants the various pieces in his victims. He's then guilty of several attempted murders and one assault. In other words, if he makes the wrong choice and assaults yet one more person, if he does that, he ends up less blameworthy than doing the wrong thing. So making the wrong thing gives him a better outcome, makes him less blameworthy under the law than if he were to stop after his harm to the first 5 people. The author then makes arguments that this is also true morally with God. I would caution you that would depend on what your beliefs are as to whether sins and actions are ranked by God, or whether God views any misdeed by a person as a sin without a hierarchical, unlike our criminal system, which says this is worse than this. So the author assumes that God also has a hierarchy in that. And so I would just caution you that would depend upon what your religious beliefs are. He then gives a few other examples, crimes of self-restraint. That's on page 130, and it's about a Douglas MacArthur story about his dad who was offered a bribe to do something that he should not have done as a leader in the army. His dad chose to get sent to a different location to remove himself from the situation and not be tempted by the bribe. So then it gives you some fact patterns in this in page 130 on what if MacArthur's father had done some small crime to get moved because he couldn't get moved. Would that have less, would acting wrongly, choosing to take a wrong action so that you don't do something worse, is that justified? So the chapter spends a lot of time talking about that, and then goes into some other analogies, making the analogy to counter preferential voting on page 133, that there are voters who will vote against their candidate so that they can get the candidates they want to be in a runoff, so that they choose a candidate that is their least favorite choice to get a candidate against their candidate that will win in the runoff. So that's explored on page 133 through 135. Then going to page 136 kind of comes to a conclusion looking at those same questions that we've looked at loopholes before. Asks the first 2 questions on loopholes, and states we get identical answers because intentional fouls, for the same reason we get with ordinary loopholes, we have them because of the multi-criterial nature of legal decision making, and as long as we remain committed to the multiplicity of criteria, we're going to see loopholes. And then it asks the third question, what should we do about loopholes? But here he comes to a different conclusion. Here he says the answer quite manifestly is that it's really quite immoral to avail yourself of the loopholes, in this case being the intentional foul. And so it's immoral to avail yourself of an intentional foul. However, if you do avail yourself of an intentional foul, you get greater moral approval, is his argument, than if not. Again, I would caution you that I don't know that it's greater moral approval. It definitely in the law, because the law ranks offenses by level of felonies and misdemeanors, that in the law there's definitely a hierarchy. Whether there morally is or not, this author believes there is, but I caution you that that's not everyone's belief. So that's the end of this section, the second section of the book. After you've reviewed this material, we will have test number 2. You've already completed the first test and your midterm exam, and then we'll move into the last section. Good luck. Thanks.